What is preemption, and how does it affect health? In this video, we're going to talk about the legal concept of preemption, which occurs when the law of a higher level of government invalidates or supersedes the law of a lower level of government. We'll talk about the different types of preemption and their implications in order to illustrate why preemption matters for public health and how it might affect your work. Let's start with a basic question. What is preemption? Preemption is a legal doctrine that allows a higher level of government, like federal or state government, to limit or even eliminate the power of a lower level of government, like state or local government, to regulate a specific issue. Under the U.S. Constitution's Supremacy Clause, federal law takes precedence over lower-level laws. So if a state or local law conflicts with federal law, the supreme law of the land, supersedes the lower-level law. Generally, a government cannot do anything that conflicts with a law of a higher level of government. Depending on the type of preemption, lower levels of government might be prevented from passing any laws on a certain issue, or they might be prevented from passing certain types of laws affecting that issue. Now, let's dive a little bit deeper into the forms that preemption can take and what they mean. The type of preemption that prevents lower levels of government from passing or enforcing any laws or regulations on an issue is known as ceiling preemption. In ceiling preemption, the whole room is filled up by the law of a higher level of government, so there is no space for the lower level of government to act. Consider minimum wage, for example. A number of states have passed laws prohibiting cities from raising local minimum wage rates. This prohibition is an example of ceiling preemption because in those states, there is no room for local governments to act. Sometimes, however, a lower level of government is allowed to regulate some parts of an issue, even when a higher level of government has a law in that area. This is known as floor preemption. The law of the higher level of government sets a minimum standard, but there is still room for a lower level of government to add additional requirements. Again, let's use minimum wage as an example. Federal law sets minimum wage rates in the United States. In this case, federal law acts as a floor. That is, it preempts state and local governments from adopting laws that set a lower minimum wage. But states and cities can still set higher minimum wage rates unless a city is located in a state that has ceiling preemption on minimum wage. In addition to floor and ceiling preemption, there is a third type of preemption called vacuum preemption or null preemption. Vacuum preemption occurs when legislators choose not to enact regulations in a particular field, but then actively forbid lower levels of governments from doing so. Vacuum preemption typically happens on the state level and so most often affects local government authority. For example, state laws can prevent localities from passing paid sick leave policies, even if no comprehensive statewide paid sick leave law exists. The result of vacuum or null preemption is a regulatory void in certain areas. It is often easier for cities or counties to enact their own laws protecting the health of their communities than relying on the state to do so. However, as more local governments do so, an increasing number of industries and their lobbies, who may disagree with these laws, are responding by using state preemption to stop local action. In this context, null preemption can have detrimental effects on public health efforts. Not only does it limit local efforts to address public health issues like chronic disease prevention, but it creates a regulatory vacuum by not establishing a statewide standard. As a result, null preemption may prevent some innovations without adding uniformity. Sometimes the higher level of government will go one step further to ensure that there is a regulatory void by penalizing lower levels of government that legislate in certain areas. This practice is called punitive preemption or super preemption. For example, a state could remove funding from a local jurisdiction that enacts laws in the preempted area. Other punitive measures might include fines for elected officials who legislate in the preempted area, giving corporations or individuals the right to sue local governments or elected officials for violation of preemptive laws, or removal from office if an elected official violates such a law. Finally, preemption can be either express or implied. In express preemption, the preemptive law includes explicit preemption language. It might say something like, all local laws on this subject are preempted, or includes similar language to that effect. This type of preemption could create a regulatory vacuum. Nonetheless, lower levels of government would not be able to regulate in that area. In implied preemption, the higher level law does not mention preemption explicitly, but something in the law makes it clear that the legislature intended to regulate the entire field. It's not always obvious when there is implied preemption, and sometimes courts have to decide whether a certain law is intended to preempt lower level laws. Implied preemption can be hard to spot. Even courts have trouble determining whether a particular law is preemptive. An attorney can help determine whether preemptive intent is implied by the context of the law, but often the final decisions about implied preemption are left up to courts. If you're interested in learning more, we encourage you to check out our free training, Preemption and Public Health, which delves into what preemption is, how it affects health, and how to spot preemption in practice. This training is part of the Public Health Law Academy, which is supported by the Centers for Disease Control and Prevention, CDC. Our free and easy-to-use trainings provide a deeper understanding of the use of law and policy to improve population health outcomes. Developed in cooperation with ChangeLab Solutions, the online trainings offered by the Public Health Law Academy are essential for all public health professionals. To learn more, visit www.publichealthlawacademy.org. The views expressed in this video, including written training materials or publications, do not necessarily reflect the official policies of CDC or the U.S. Department of Health and Human Services, nor does the mention of trade names, commercial practices, or organizations imply endorsement by the U.S. government. Like all materials associated with the Public Health Law Academy, this video provides legal information but not legal advice, and no attorney-client relationship is created. Please contact an attorney in your state if you need legal advice. Furthermore, the information provided in this video is for informational purposes only and does not constitute legal advice. ChangeLab Solutions does not enter into attorney-client relationships. And while every effort has been made to verify the accuracy of these materials, legal authorities and requirements may vary from jurisdiction to jurisdiction. The contents of this presentation have not been formally disseminated by the Centers for Disease Control and Prevention and should not be construed to represent any agency determination or policy. Always seek the advice of an attorney or other qualified professional on any questions you may have about a legal matter.